All right, good morning, haters. It's time for another episode of I Hate Real Estate with my good friend, Kendall Grooms. Good morning.
Hey, Jamie.
I'm Jamie Taylor, and I'm broadcasting with my friend Kendall from the Esplanade District. We are sponsored by American Abstract and Title Company, as well as the best attorneys in town, Campbell and Grooms. And this morning, we're going to talk about your favorite document in the whole wide world, the Earnest Money Addendum.
I don't like it.
If you're listening outside of Arkansas, you just definitely learned from our mistakes, one. And two, if you're listening in Central Arkansas, you're a real estate agent, broker, or attorney, consumer, anybody who spends money on real estate and thinks that earnest money up front is a very important factor. Tune in. It's time to go. So tell me, full school and 7 years ago, when the Earnest
we've talked about Arkansas being the model state for the forms that they use and the process that they go through, and it's taught at Stanford Law School and all this stuff. It shouldn't be on this point. The earnest money is terrible. The earnest money requirement. It used to be that people thought earnest money was a requirement because you'd have to have some consideration for a contract.
And for example, that means just like I can pony up the dough. I'm going to be able to go through with the deal.
Consideration, it's a legal term. Consideration is a promise for a promise. But somebody down the road somewhere ignored the fact that I'm promising to pay you $250,000 and you're promising to give me your house.
Right.
That's consideration. Why we needed this extra. Well, to start this process, we have to have $500 up front or $5,000 up front or $50,000 up front, whatever it is. I don't know why that got started.
Well,
I
think
don't understand it.
Outside, I would have thought that that's because it's kind of like when you get a down payment on a house or a down payment on a car, but you can't necessarily do that up front when you're financing the house. So maybe the earnest money is just a show of good faith.
It could be. And but there's no requirement for it.
Right.
I mean, you've already executed a contract, and there's all kinds of provisions in there of what happens to the earnest money. It's not like a situation where if this house doesn't close, you get this money.
But everybody thinks that, and that's
dependent. It's dependent upon all of these other factors, and it creates legal nightmares. Mm-hmm. Because then all of a sudden somebody won't terminate a contract, or they won't agree to terminate a contract, or they won't close, and the next thing you know, the title company's holding $250 in limbo forever, and somebody has to hire an attorney to try to get it. Well, you can imagine that attorney's fees and costs to go try to recover $250 of your money.
But the other part of it is what you're saying is, so what I've experienced, at least on the other side of bad earnest money, is people do assume that if someone puts earnest money down,
that it's theirs.
And if they terminate the contract for any reason, it's theirs. I've also dealt with the misconception that earnest money does not apply towards the purchase of the property, but as an additional deposit that just gets put in your pocket.
That's the whole consideration thing. It's kind of like where an attorney used to have a retainer.
We don't have a retainer?
There's no true retainer anymore. It's a deposit against future billings. You used to have a deal where an attorney would say, yeah, I'll be your attorney. I'll hold the spot. If you get sued, I'll be your attorney. I won't take on representation of anybody else conflicting with this, but you have to pay me $2,500. And that was the attorney's money.
Right.
It was done. That's no longer
But he also
exists.
has performed too, so.
Yes, but it's the same type of thing. That's the attorney's money, and the attorney's done nothing other than say, yes, I'll be your lawyer in the future.
So when I got to Arkansas, I had to take the licensing exam, obviously, and get my license here. But this was something that has changed kind of along the course of the time that I've been in the business. So before I got in, there was not an earnest money addendum. That was a new form, right? When did that come out?
2016.
So yeah, that makes sense.
Because I know why. So this evolved. The earnest money evolved over time to where it was this consideration. And then the contracts got revised to where you basically had the option. If you were damaged under a contract, you could keep the earnest money or a deposit if it was not on the form. You could keep that as your, quote, liquidated damages, so that if you took that money, you didn't have a right to go file a lawsuit to pursue any other remedy.
With
that way, it's basically an agreement that these are the damages if something happens. Whoever the party is at fault, you can leave it with them. Well, that allowed the title companies to deposit the money into their registry of the court under what's called an interpleader and say, Judge, here's $5,000 that's in our account that's not ours. It's one of these two people. You figure it out. And that's where they would go forward. And then, of course, you get more litigation. So all it did was allow this issue of back and forth with the title company. It allowed the title company to defer that money into the court.
Okay. But that at least takes it off their hands. And
Yes.
as everybody knows, or if you don't know, if you're managing any sort of brokerage account or touching other people's money, the bookkeeping is extremely important.
It has to match to the penny every day.
Every day. And so you can't have one day where there's the 5,000 and you don't have an explanation as to why that's in your account. So you have to have what you're talking about, the interpolator.
That's the fastest way for the real estate commission to pull your license.
Immediately. Yeah. You can't mess up your trust account, not even a little bit too. And I know it's different for title companies, what kind of
Real
accounts they
estate,
have,
title companies, lawyers, anybody that has some kind of governed trust account like that.
I don't miss the days of being over that account. But anyways, that being
well, then it evolved. So that was kind of the next step in 2015. We actually went and litigated in 2015 a case that had to do with the real estate contract and the seller's disclosure.
But did the real estate contract, and I was going to ask, previously the real estate contract had its own section in there for the earnest money addendum, and now it is separate. So, okay.
It was like paragraph 5 or 6 or whatever it was of the 2015 and earlier real estate contract, the form contract. After 2015, when our litigation ended, we had a big issue with the attorney's fees section in the contract because we prevailed, and there was a big argument. We ended up winning the issue, but there was a big argument about the interpretation of, there's a paragraph at the bottom that says if there's any litigation, the prevailing party gets their attorney's fees and costs paid. But it always has this qualifier of reasonable, or it just says attorney's fees and costs. It doesn't have a qualifying word.
Right.
Or it leaves it up to discretion what your attorney's fees and costs actually were. And you're going, no, the attorney's fees and costs are what I paid.
Right.
And so we did some research, and there's other states, and there's been interpretations under Arkansas law as to exactly what language would need to be in the contract. And so we reached out and said, fix this. And they told us, y'all fix it and send it to us, and we'll go to committee and propose these changes. When we did it, we had multiple issues with the earnest money in the past as well. And so we completely eliminated it from the contract in 2015.
Here's what we're going to do. We went back to the drawing board.
It was this big red block. Get rid of this thing. And it went to committee, and they approved it. And I think if you go back and you look at the 2016 form, there is no earnest money in the 2016 version of the form. And there's no non-refundable deposit either. Well, real estate agents, no offense, couldn't handle it.
Don't talk to me like that.
Handle it. Everybody's up in arms. Where did my earnest money go? These people want money up front. These people selling this house want these people to put $10,000 down, or we're not signing a contract. Where's my earnest money?
Can I just say that for some reason, all of a sudden in my mind, I'm thinking like, I bet you mortgage lenders hate earnest money too, because this is just a big financial deposit or withdrawal from their account prior to the purchase. Anyways, continue.
So we go forward and we're talking with them about how to fix it. And they eventually say, yeah, we're not listening to y'all anymore. The realtors are unhappy. And so we end up in the midst of 2016 with the earnest money addendum form. It's a separate form where if somebody wants earnest money, they drafted this whole new form, and it dealt with all
2 pages long.
Yeah, it dealt with contingencies about if this person's at fault, the money goes here. If this person's at fault, the money goes here. But then when the 2017 version of the forms came out, not only did they keep the addendum for use, but they also added earnest money back into the contract
and
could be used. And they added a new term called a non-refundable deposit, which is even worse because one would think that a non-refundable deposit is what?
Earnest money.
Non-refundable.
Well, but still, it's the same as, I see what you're saying. But the thing is, you can't put those both in the contract and then have
retainer. The retainer that we talked about is I'm giving you $1,000 for the right to negotiate this contract and buy this property. And it's non-refundable. It's yours to keep. It doesn't apply towards the purchase price. That's what a non-refundable deposit should be, but it's not what it is.
No, but perception is reality for people. And that's why I say it's basically earnest money in my mind. Because when people put earnest money down on a property, the intention is I'm doing this because the seller wants me to do it in order to beat out other contracts, and or there's some other reason why they don't think I'm going to close. So they want me to good faith put this down and show that I'm serious.
Yes.
The non-refundable deposit is essentially the same thing because you could fight that and try to get it back with attorney's fees.
But it's even more confusing because in the contract it says here's who gets the non-refundable deposit in these instances, and there are circumstances where the person who deposited the non-refundable deposit can get a refund of the deposit. It makes absolutely no sense. It's a second earnest money is all it is. It's a second option for earnest money, and it's a negotiation tactic. Mm-hmm. It's nothing more than for negotiation on the transactional side that realtors use and that buyers and sellers use.
I'm sorry to interrupt this riveting conversation, but it's time for a word from our sponsor. This episode is sponsored by American Abstract and Title Company. Not only does this place handle most of the real estate transactions that go down in Pulaski County, but they do it with professionalism, and no one has more energy than their fearless leader, Andrew Atkins. If you have any concerns whatsoever about your title work, bring your file over to American Abstract Title and know it's going to close on time and in style. I have used American Abstract Title for more than one transaction in my real estate career, and they are not one of the reasons why I host a show called I Hate Real Estate. Remember, at the end of the day, we don't really hate it, we're actually great at it. So, my friend Andrew Atkins and American Abstract Title is the place for you to close your business. This episode is brought to you by Campbell & Grooms Law Firm. This small law firm has the tenacity to go after the big guy when your HGTV situation doesn't turn out so great. Remember, we started this show for a reason, and these guys know what to do when things turn upside down. Donald Campbell and Kendall Grooms are the Arkansas Trial Lawyers Association Trial Lawyers of the Year for 2019-20, and I'm pretty sure 21's in the bag. Well, and I think I want to
pointless.
And that's the thing. I mean, PSA from my side, which I know is like one of the reasons why I'm in this interesting position, is I don't care if you don't agree with me, in the sense that as an agent, I hate earnest money. I don't want it. When I was a broker, I didn't want it because I was constantly having to keep track of who was doing earnest money where. Plus, I felt like every time something came apart, the earnest money was the number one thing that both of them were mad about. And no matter how many times I would explain, it is very possible that this money is not going to be yours. It says right here, actually, let me find it. If the buyer fails to fulfill his obligations under the contract, or if after all conditions have been met by the buyer, they fail to close, the earnest money may, at the sole and exclusive option of the seller, be retained by the seller as liquidated damages. Mm-hmm. That is not always true, though.
No.
And so you can't, a seller reads this and they're like,
but all this does is create
issues.
The way I put it is that it's a pissing contest.
It is.
Now all of a sudden, it's the contract has put it to the discretion of the parties involved to determine whose fault it was that the deal didn't close.
The other part
that's insane.
And they're also letting them decide whose money, who gets the money based on that decision, which they're not the ones to determine who went wrong where. That's actually my job and your job. So it's interesting to me that this happened because, like you said, with the model state, we really have pretty ironclad contracts that make a lot of sense, except for this one. What if you had to rule on a new, like, obviously not rule on because you're not a judge, but we talk every week about what the solution for some of these things could be. Now, from a consumer protection standpoint, the way that I look at this is, as an agent, as a broker, I approach my seller. Hey, seller, I know we're in this crazy market and we're asking people to do a lot of things to beat other offers out. I want to be upfront with you right now. That money up front could very well be gone, just like that. If they don't close, if you don't do something, if they get an inspection and they ask for every item on the inspection to be repaired, and you think that they're all ridiculous and you decide I'm out, you still don't get to keep their money. You know what I mean? Like, describe it to your seller as though this is only just an extra level for negotiation. Not probably going to keep that for any reason. I just can't even imagine a scenario where the seller would be able to keep it.
I mean, you have scenarios where a buyer doesn't qualify for financing.
Well, and that's different. But at the same time, as a buyer that doesn't qualify for financing, why would your agent recommend you put money into something that you could possibly lose?
You shouldn't. But things could happen in between. I mean, you could have somebody lose a job a week after they make an offer on a house.
But again, then they're spending money that they don't have.
I can see the circumstance where it could occur, but it's not common. It is not common that it is a buyer's fault. You'll see it a lot more times that a seller can't provide good title. Like, they find out that there's a title issue on their property,
or inspection,
they can't close, or there's a horrible inspection
appraisal
at the property, or they turn over the disclosure. You're not technically required to turn over the disclosure until 3 days after the contract is executed. Right. What happens if the disclosure says this is in a flood area, or we had this massive flood at the house?
Died here.
Yeah, somebody died here, something like that. And you say, I want out. That's your money to get back.
Right.
But it's going to cause a fight every time.
That's the big thing, is for me.
Because then you have the other problem that we've talked about before, is that the termination is mutual. It's not a unilateral option of the buyer to say, I'm terminating this contract. Even if you do, the parties still have to both sign an agreed termination. And the termination document says who gets the earnest money or who gets the deposit back. And that's where the problem arises.
Well, and I feel like typically I'll try to push you a little bit on some stuff, but this is one of those issues like I'm 100% on your side about, because In commercial real estate, now that's a little bit different, and it depends on, you're still using contracts here, and you can still use earnest money, you can still use deposits in commercial.
You're expending large amounts of money in investigation and inspections, though. In those.
Yes, and in those situations, I have seen earnest money used fairly successfully, because it's a situation where like they go in, they really want the deal, they've got to put a substantial amount down to show that they're a qualified buyer, but that they're also not full of it, because they're going to have to go through and do an environmental and all these other inspections. So I've seen that used. I've seen a $50,000, $100,000 upfront earnest money, non-refundable deposit. I'm going to close on this, or you can have my money. But it's still, again, I think perception is reality, and expectations are killer in this situation. So especially if you're buying a house, but even more in commercial, when you're expending that money, you have to understand that you are giving that money away with every intention, usually as the buyer, of getting it back if things go wrong. And as the seller, you're already counting it as having been received, not thinking about, unless your agent is obviously smart enough to tell you that you could very well.
The thing about that is the commercial contracts are a completely different animal from what we're talking about. I mean, we're talking 30, 40, 50 page contracts, whether you're doing a construction project on an AIA form, or whether you're just doing one straight yourself through an attorney or someone that's sophisticated in commercial transactions,
we have them
or just
here.
using the commercial form. Even that handles things differently. So I do have a fundamental problem with what earnest money and this non-refundable deposit cause, but it could be solved easily by way of a revision to the form.
Well, it just
and
would
still
be
in the forms if somebody is adamant that it be kept, which clearly they are.
Well, I just
because
think general
we got it taken
addendums
out and they put it back in.
Well, but I mean, general addendums take care of everything, right? And that's like in my personal opinion. Again, I don't write laws, and I don't write legislation, and I don't write contracts. That's your job. But if you just put on a general addendum that the buyer's going to put this much money, and the seller's going to understand that very well may not be theirs if something doesn't work out, if you just line for line put that together, even like remember when they did the COVID-19 clause immediately when that started happening, you dropped a clause in the contract? If there was just a clause that you could just drop in every time that pre-approved language, and it just dropped in, and you just take everything else out of the contract, I really think that it would just clarify this, because I think who gets damaged the most by this are the participants in the market, because those of us who are relaying the information, either we didn't relay it properly, or we didn't relay it in a way that they genuinely understood it, because you and I both know that the majority of fights that happen over money in real estate, and they very easily happen over earnest money.
You get sellers all the time, even if it's their fault. They don't want to admit it's their fault, because they don't want this stigma on their property that says, hey, we had a deal fall apart. They don't want that, because you have to disclose that. If you have a deal fall apart, you have to go back on your real estate, on your seller's disclosure form, and say, yeah, somebody made an offer on this property and they didn't close on it, and we accepted it and they didn't close, and here's the reason why.
Hey, FYI for you SPD filler outers, make sure you're going back and updating that, because deals do fall apart. And I think that's
I've never seen an updated seller's property disclosure after the first one.
That is a practice that I think is missing. We could bring that up at some point in the future, but I think even for right now, just a quick mention, PSA, that you should be updating your seller property disclosure if something happens.
We talk about it all the time. We do need to do a show and actually walk through the details of that document.
I think we'll have like a seller property disclosure walkthrough, but you know what we should do? We're going to holler at Maurice and be like, Maurice, will you walk us through forms once a month on the show and walk us through all the things you see? And then Kendall can be like,
Yeah, we can do this little, take out the earnest money.
Take it out. Yeah. We'll see. We'll see if we can get it out. Here's the thing though, reality. As a member of the industry, what would you say is the proper message to relay as a listing agent or as a buyer when your client is adamant about using earnest money, but you have the knowledge and understanding that you and I do about the pointless nature of said earnest money?
If I'm the buyer, I'm not wanting to put it down, period. I don't want non-refundable deposit, don't want earnest money.
Makes me feel weird.
I know. But if you've got a seller on the other side and the single holdup is, I want $500 in earnest money, or I'm not accepting your contract, I guess at that point you have to weigh whether or not it's worth it to you to lose $500, because it is not worth it if it falls apart to go fight over who gets that $500, because it's going to be expensive. Even if you don't have to hire a lawyer, it's going to consume your time in dealing with it and going back and forth and pointing fingers
and the energy. And then as an agent, you don't want to get tied up in that.
You're the one that is also going to incur additional expense, because you're the one that's going to pay for an inspection report. You're the one that's going to apply for financing, and the bank is going to charge you to get an appraisal done. Those are the things. So it's not just the $500. It's other expenses that may be out of pocket, but you just have to weigh the cost benefit. If someone says we want $5,000 in earnest money, or we're not taking it, then you really have to weigh the benefit, because 500 is one thing, 5,000 is another. If you get somebody that says we want $50,000, you need to walk away from that property.
Yeah, unless it's commercial.
Unless it's commercial. Residential property, you need to walk away.
Yeah. Well, and the thing is, I appreciate you just saying it like that, very plain language. And if you're listening to this and you're an agent, you're not sure, always feel free to hit us up, send us an email. We'll listen and we'll respond and tell you what to do, in the sense that you will not have to give any legal advice. But from real estate experience background, it is very important to relay these messages properly. Listen to where you can get the information in your market, understand what the form says, and then relay that information to your client, because what always happens is you're getting a hold of it when it's too late. At this point, everybody's fighting. And I just want to bring back to the top, as an agent, as a broker, you're going to have to wait till the complaint's done too. Like, you have to deal with this while you're dealing with other transactions. Whatever went wrong with this earnest money is going to be your responsibility until they figure it out. So you don't want to get tied up in that.
I can't tell you how many times that I've gotten a call from somebody and said, hey, I'm entitled to $5,000 of my earnest money back, but they won't give it to me. Like, and I say, well, if we go litigate this, you're going to pay me more than $5,000 to litigate it. It's just going to happen between costs, expenses, and attorney's fees. It's not worth it for you. Let's settle it. And we end up doing a $2,500 settlement split. And the parties say, we'll each split the earnest money and we'll walk away and release everybody from all other claims. That's why it's a problem.
Gosh. I just think
it's
that
the intermingling of the forms. It's the intermingling of the earnest money, of the contract that has the earnest money and the non-refundable deposit,
plus the
potential addendum that can be out there, and the termination form being mutual if something occurs.
That's three forms that are tied all together with one piece of money, one check. And our good buddy Andrew over there at American Abstract does not appreciate it when y'all leave your earnest money sitting in his trust account, because
he does not want to call his lawyer and say, hey, we need to get this to the court.
No, he doesn't. So we're going to try and save you from that, AA. We're going to keep it going on here and tell everybody what to do when earnest money becomes part of their life. Also, a big shout out, though, to our pre-filled forms. At least if they're going to be there, they're pre-filled and they're super easy to deal with. So to all the agents and brokers in the room, make sure that you're paying attention to all the things you learn on I Hate Real Estate, because Kendall and I will keep coming back week after week to give you more information to be better equipped in serving your clients. You're going to have to rule on this one on the show.
Oh, yeah, it's easy.
So here we go. Earnest money addendum or no earnest money addendum?
The earnest money and the non-refundable deposit, they need to go.
Bye. Goodbye, earnest money deposit. So, haters, my gavel, my gavel. Kendall's gavel has spoken. Thanks for tuning in to another episode of I Hate Real Estate. You got to be safe out there, and remember, for your protection, get a home inspection. I'm Jamie Taylor. We'll see you next time. Kendall?
Bye.
Bye.